referenced in AT&T's position statement, for some reason, AT&T for some reason, AT&T did not submit this critical piece of evidence, material evidence, as an attachment. Therefore, on July the 8th, 2015, the EEOC emailed AT&T for a copy of my personnel file. They didn't get it. Additional information. The commission is courteously. You have not provided the below requested information. A complete, unredacted copy of my personnel file. I'm the charging party. I don't want to be forced to contact the respondent directly, so on and so forth. So this letter was sent to AT&T from the EEOC on July 8, 2015. Now this is after my attorney had submitted the rebuttal on May 15, 2015. Then we see on July 13th, 2015, AT&T's representative, Kathy Bahramian. Again, this is on July 13, 2015. She responded. She didn't have the personnel file. Now, I'm not sure how you write a position statement without a personnel file, but that's just me. But she also provided a final warning letter. But this one was dated February 2013, not March, which is the time, which is when I got it, March 22nd, 2013. So in fact, AT&T's representative, Kathy Bahramian, responded with another falsified document. By sending Lucy Camper, the EEOC's representative, a final warning letter dated February the 22nd, not March the 22nd. So let me show that to you. Again, here's her response. She's sending as an attachment this final warning letter dated with a date of February 2013. And here's the actual copy of the letter. Kimberly Brown, February 22nd, 2013, final warning letter. What did the EEOC do? Well, once again, they failed to disclose this newly acquired evidence, a final warning letter dated February 22nd, 2013, to me, and once again, denied me the opportunity to overcome the burden of proof. In the EEOC's failure, it sought not to discover through ordinary diligence the facts as to which document was the original. A document discrepancy appearing now for the second time from AT&T's representative Kathy Bahramian demonstrates with more than questionable reliability that material evidence was being submitted to a federal agency during an open investigation, yet the EEOC made no attempt to uncover the fallacy. In light of these discrepancies, now known by the EEOC, once again, they failed to allow me my legal right not only to overcome the burden of proof, but also to examine the investigative file and notify them of any perceived deficiencies prior to issuing its final decision, once again in accordance with its own stated policies. Had I known of the email communication dated July 13, 2015 between AT&T and the EEOC and this newly acquired evidence, this version of the final warning letter dated February 22, 2013, I would have requested that the EEOC issue a subpoena to compel testimony by production of evidence under a penalty to obtain the original final warning letter and all related conversation about the document. Most importantly, had I known about this newly acquired final warning letter maliciously falsified with a date of February 22, 2013, I would have submitted into evidence an email transmission that demonstrates that the final warning letter dated March the 22nd, 2013, included as an attachment, was given to me on March the 22nd, 2013 by Susan Clark. So I'm going to show that to you. Email Susan Clark sends Kim Brown this email March the 22nd, 2013, a final warning letter. Kim Brown, March 2013. And here's the attachment. Again, dated March 2013, not February 2013. And here's where the email is located. And here's the original document. As you can see, it's unsigned. March the 22nd, 2013. Now, I would have requested that the EEOC conduct a face-to-face interview with Susan Clark on the penalties of perjury to determine the validity of the email dated March 22nd, 2013 and its attachment. Based on the evidence included in the Freedom of Information files, the EEOC never questioned the credibility or legitimacy of the unsigned final warning letters or the date discrepancies, which it identifies in its own processes as a means of determining reliability. Again, the EEOC identifies in its own processes a means of determining document reliability based on signatures and dates. I'm going to share with you again that document. Here's where it's located. And it comes under reliable evidence. And it states, some factors to consider in determining whether documents are reliable are whether they are obtained from the custodian of records. Kathy Baharamian is not a custodian of records, or the author of the document, or whether they are copies of or the original documents, and whether the documents are signed and dated. And as you can see here, there's no signature, there's no date. By failing to disclose this newly acquired evidence and by failing to enforce its own documented policy, once again, the EEOC denied me my legal right to examine my investigative file prior to issuing a final determination. Clearly, the EEOC demonstrated a concerted effort to intentionally defraud me. I relied on the EEOC to conduct an unbiased, impartial investigation. I relied on the EEOC to fully disclose all material evidence. I relied on the EEOC to publish a succinct investigative summary, citing to evidence collected. Unfortunate for me, I relied on the EEOC's deception. By the EEOC's hindrance of their own processes, I was denied my legal responsibility to overcome the burden of proof, where decisions are made based on the preponderance of evidence. Excuse me. At this point, I have demonstrated several counts of criminal fraudulent concealment committed by the Atlanta District EEOC office. So in May 2016, I sent an ethical complaint against Lucy Camper, alleging that the Atlanta District Office excluded, removed, withheld relevant material evidence from its investigative summary dated May 5th, 2015. I sent that letter to Office of Field Program Representative. And in this response came from the DC office, the Field Program Management Office, dated June 1st, 2016. It remains silent on the concealment, suppression of material evidence, and thereby continue the fraud. Still, with no answers to my concerns, in June 2016, I escalated the issue to Jean L. Dodaro. As you can see here, I sent this letter. To Jean L. Dodaro at the Government Accountability Office, who investigates allegations of illegal and improper activities to date. And today is October 2nd, 2016. I've received no response, not even an acknowledgement letter. And believe me, I confirmed delivery and pickup by his office. I also contacted the Office of the Inspector General, EEOC branch, under the direction of Milton Mayo in June 2016, who investigates allegations of fraud, waste and abuse, violations of the law, and misconduct by agency employees. Once again, I confirmed delivery and signature acceptance by his office. Yet I have not received any response, not even an acknowledgement letter, which is a written requirement according to the EEOC's policies. And according to its policies, that acknowledgement letter should be executed within 15 days of its receipt of the letter. Let's not forget about AT&T. What was AT&T trying to conceal by falsifying multiple documents? Is this their first time falsifying documents? It's just a question. Psychologists say that when you get away with a lie, it often impels you to continue your deception. Psychologists also suggest that liars often find themselves perpetrating more untruths to cover themselves or avoid punishment. Final question. Is AT&T and the EEOC held to a different standard when it comes to telling the truth? And more importantly, If